Good afternoon, and for those of you joining us from the West Coast or further west in Ontario, good morning. Welcome to the second part of the Williams HR Law three-part New World of Work Hotspots webinar series. Today, we're going to focus on employment standards in the new world of work. Now, before we get into any content here this afternoon, I'd like to acknowledge that we're presenting to you from land that is the traditional territory of many nations, including the Wendat, Anishinaabe, Haudenosaunee, Métis, and the Mississaugas of the Credit First Nation, among others. We recognize and deeply appreciate the historic connection and contributions that these Indigenous cultures have to this place in which we're privileged to be. Now on to the content. As those attending today will know, employment standards legislation forms the backbone of HR law in Canada. Most employers are subject to provincial employment standards legislation. So for those of you in Ontario, that's Ontario's Employment Standards Act 2000, or ESA. Now, employers in certain industries, including telecommunications, banking, air and rail transit, and certain others, are federally regulated, and their employment standards legislation is the Canada Labour Code. Given that most of our attendees here today are primarily based in Ontario and are primarily provincially regulated, we'll primarily focus on Ontario's ESA, but we will touch on how these concepts apply to other Canadian jurisdictions throughout. Now, with the way that we work having shifted so much since the beginning of this pandemic, and many employers finding new ways to do their work, including most notably working remotely more and more, there are many new risks and considerations that employers need to consider from an employment standards perspective, and those you really need to consider while you determine how you're going to work in this new world of work. Now, this results from a couple of different things. First of all, the way that the ESA and similar legislation applies is really different now that work is being performed differently. And on top of that, we're starting to see some significant amendments to the ESA that are reflecting this new world of work that need to be considered as well. So at the end of the webinar today, we're hoping to leave you with a much greater understanding of how employment standards impacts your organization in the new world of work, and to give you some key new best practices to minimize the liabilities related to employment standards. Now, before we get started, I want to touch on just a few housekeeping items. First of all, keep in mind that we're going to leave time at the end of the presentation to answer your questions, but please submit your questions throughout the presentation as they come to you. Now, I will note that you should keep in mind this is an educational session, and this should not be considered specific legal advice because specific advice needs to take into account your specific circumstances. If you have a legal issue, we encourage you to get specific advice about that issue. Now, we have a big turnout today of a few hundred attendees, so we do expect to receive a lot of questions. It's for that reason that I said, please send your questions in throughout the presentation. In addition to that, because we have so many attendees, we expect to get a lot of questions. And so we're happy to stay on for an extra 10 or 15 minutes after the scheduled end of our 1-hour webinar in order to answer any questions for those of you who do have time to stick around. Now, what we'll ask you to do when it comes to your questions is to post any substantive questions that you have about our content that you'd like us to address at the Q&A session. Ask those in the Q&A box in Zoom, as opposed to the chat box. Any technical questions that you have, if your audio is not working, the video is cutting out, that sort of thing, please post those in the chat box, but otherwise keep your questions to the Q&A box to ensure that any technical issues can be addressed promptly. Now, the last point I'll make here is that following the presentation by early next week, we will be sending the slides to everyone who's registered, along with a link to view the playback of the presentation on our COVID-19 Resource Center. The COVID-19 Resource Center is a page on our website that we've created and we've been maintaining throughout the pandemic since early in the pandemic in March, April 2020. And we're constantly posting new videos, articles, updates on there about what employers need to know and need to understand when it comes to COVID-19, case law related to COVID-19, best practices, new legislation, whatever the case may be. We're regularly updating that, and that is where we're going to be posting the playback of today's presentation. So with that, let's dive into the presentation. I'm just going to make sure I can use my arrows here. Perfect. So to introduce myself, first of all, I'm Joel Smith. I'm a partner at Williams HR Law, and I practice along with others in the firm in all areas of labor and employment law across Ontario and again across the country as well, with the sole exception of Quebec. I'd like to introduce you now to Sheldon Jean-Baptiste. Sheldon is another one of the lawyers with the firm who similarly practices all areas of labor and employment law and is also a workplace investigator. And last but not least, I'm excited to introduce you here today to Nhi. So Nhi is our new lawyer, just joined the firm last week. Nhi has years of experience practicing in labor and employment law, including advising employers across industries in all areas of labor and employment law. So we're excited to have her here and so thrilled that you all have the chance to meet her here today. With that, I'm going to jump right into our agenda. First of all, the first three segments of our presentation here, we're going to use real world scenarios that we've been assisting our clients with to help illustrate some of these issues for you. So Sheldon and I are going to bring you through these scenarios, which will address which employment standards applies. What we mean by that is whether the Ontario Employment Standards Act applies, whether another provincial employment standards statute applies, or otherwise when employees are working in different places, including outside of Canada and outside of Ontario. We're then going to use a scenario to talk to you about overtime and hours of work liabilities and issues that really have been arising more and more throughout the pandemic and that are really important for you to understand. And lastly, we're going to be using a scenario to talk to you about layoffs and terminations. And as part of that, we're going to talk about some of the new provisions in the ESA that have been created in response to the pandemic, including the infectious disease emergency leave. Following those three scenarios, we're going to shift over and Nhi is going to bring you through some really key trends to watch as they relate to employment standards going forward. We actually have some brand new hot off the press content that we want to share with you that Nhi will be speaking about. And that is a brand new piece of legislation tabled just this week that's going to create some new obligations for employers in Ontario, including with respect to banning most non-competition clauses in employment contracts, as well as implementing a new obligation for most employers to implement right to disconnect policies. So I'll leave it to Nhi to tell you more about those in a few minutes. At the end of the presentation here today, we're going to speak to you about some best practices, how you can take the lessons that we're going through today and implement those in your workplace to ensure that you minimize your liabilities, protect your business, and really work to thrive in this new world of work. With that, I'm going to take us into our first topic, that being which employment standards apply. And so I'm going to pass it over to Sheldon, and Sheldon's going to take you through the scenario here that we want to speak about.
Thank you, Joel. Given the weather we've had over the last week or so, honestly, who wouldn't mind being on the beach right now in exactly the same setup as in the photo? Clearly, that's not my reality or many of yours for that matter. However, it has been a reality for many employees since the beginning of the pandemic. A common challenge for many employers during the pandemic is discovering that their employees are not working from their home offices as they thought, or they have allowed their people to work in other locations, but they have had a hard time getting them back to work. As we enter to the new world of work post-pandemic, there are some challenges that employers will continue to experience. So on behalf of one of our clients, our firm dealt with a matter where an employee in the IT department went to speak to an executive of the company and asked if he could work remotely from their home country in South America, mainly because his family member was ill. The executive approved his request informally, but they had no discussion about how long this employee would be away for, or what the parameters would be, since many of the employees were working from home anyways. At the time, HR was not told about this situation, and the company did not have any remote work policy or any sort of working abroad policy. After some months, this situation got on HR's radar, and HR reached out to us to seek advice because they were not sure of their liabilities in these circumstances. HR spoke to the employee, and he mentioned that he did not actually intend to return back to Canada in the short term. And as I mentioned earlier, although the executive thought that the employee would come back to the country much earlier, there was no prior discussion about that previously. While the employee was in South America, unfortunately, his family member passed away. So HR was trying to be compassionate towards the individual, while at the same time trying to protect the company's liability while he was working remotely in another country. The employee did ultimately return back to Canada, but it did take quite a bit of time before he left South America. This is a very common theme that employers have had to deal with, mainly where are employees allowed to work? And if they are allowed to work remotely, do they have to work in Ontario, within Canada, or are they allowed to work in another country? I'm going to turn it over to Joel, but before I do, I want to ask you this question, Joel. What are the legal implications of employees working remotely, either in another country or another province?
Thanks, Sheldon. And as you say, this is something that's been coming up so often. We've been helping our clients with these types of issues. And a lot of employers think that there's not too much issue. We don't realize that there are issues associated with these types of remote work arrangements. They think that the company is based here in Ontario. The employee was working at the Ontario office previously. They're continuing to support the company in Ontario. In many cases, their employment contract and the company's policies reference the Ontario Employment Standards Act. So the ESA must apply. Isn't that obvious? Unfortunately, it's not that simple. And in many cases, that's not the case. Generally in Ontario, the ESA applies only where the employee's work is performed in Ontario, or the employee's work is performed in Ontario and elsewhere, but the work outside of Ontario is a continuation of the work in Ontario. Now, every province's employment standards legislation is a little bit different on this point, but most are fairly similar to Ontario's legislation in this way. It really sets out that Ontario work, or primarily Ontario work, is the work that will have the ESA applied to it. So what does this mean where an employee goes to work elsewhere for employers? Well, if they go for a couple of weeks, they go to Costa Rica or Barbados and spend 2 weeks working on the beach, well, likely the ESA is going to continue to apply to them. That's a short-term temporary arrangement. It might be argued that that is a continuation of the work in Ontario. But what about the more common scenario that we've been seeing recently, where employees go away for a few months to another province or another country, or they actually move indefinitely to another location, another province or country? Well, in those cases, the ESA likely will not apply any longer. So once they've moved, they've made that decision to go elsewhere, the ESA, including the protections for employees, but also the protections and entitlements for employers, are no longer going to continue to apply in that case. A very similar concept applies where employers might hire new employees who are intended to work remotely from outside of Ontario. A lot of employers these days are thinking that, look, we're in a remote world now. We've shifted so much. Our employees can work remotely. So I have such a great talent pool really across the country and across the whole world now that I can choose from to perform the work. And then in some cases, that also allows for employers to take on less expensive talent as well because of the cost of living in other areas. And that absolutely is true. There can be a huge benefit to employers to doing that. But in doing so, employers need to understand that Ontario's ESA is not going to apply in the vast majority of cases to those employees, and they need to make sure they take steps to protect themselves if they're going to take those steps. So, like I said, this general principle applies whether an employee is working outside of Ontario in another province or a territory, or if they're working in an entire another country. Now, if the employee is working in another country, there's more complexities to consider as well. If they're working in that other country overseas, then that country's legislation, that country's laws may well apply, and in many cases will apply to that employment relationship. And in those cases, employers really should be considering getting advice from counsel in those countries to understand what legislation applies, what the rules are for their employers in those countries, so they can make educated decisions and be fully aware of what exposures they might be facing as an organization. Now, if employees are in another province, generally, if they've moved to or they're spending a long time in another province, they'll be subject to the employment standards legislation of the province in which they're working. And so the question you might be asking yourselves now is, what does this mean for me as an employer? Well, one big implication of this for employers that is under the radar for a lot of employers is that if you've taken the time, spent the money, obtained counsel to help you draft good, solid employment contracts with termination clauses that limit your employees' termination entitlements from the up to 2 years at common law down to potentially as low as up to 8 weeks under the Employment Standards Act, where you've taken the time to create these contracts, paid for them, implemented them with your employees, You might not be able to rely on those anymore. In most cases, if you have an employment contract that has clauses that reference the Ontario ESA, and most importantly, that rely on Ontario's ESA, such as many termination clauses do, you're not going to be able to rely on that in most cases any longer, because that's not going to necessarily comply with the termination legislation that is set out in employment standards statutes in the province that the employee is in. And so you might, not without realizing it, be taking on huge liability if you need to let your employees go. Similarly, there's other types of obligations in other provinces that employers may not be aware of and may not be live to. A big question that we get is holidays. If I have an employee in another province, surely they're still subject to our holidays because that's how we work, isn't that right? Unfortunately, no. If an employee is in another province that has different statutory holidays, the default rule is going to be that they're entitled to the holidays under the applicable legislation in that province. Overtime entitlements is another big one as well. Every province does overtime a little bit differently. Here in Ontario, most employers will know that the overtime threshold is 44 hours per week, and there's no daily overtime threshold. That's not the same across the country. Out in BC, for example, the overtime threshold is both weekly but also daily, where employees are entitled to overtime pay after 8 hours in a day. So these types of things really need to be considered by employers when you're considering allowing these types of arrangements. Now, I don't want to spend a lot of time. We've committed to speaking about employment standards here today after all, but I do want to touch on very high level some other legal implications where employees are going to be working remotely, and particularly remotely outside of the province or outside of the country. A big issue to consider is health and safety. Generally, employers will still have an obligation to ensure their employees' health and safety where the employees are working in another province or overseas or from their home somewhere else. And so because of that, employers really need to be mindful and consider, how are we going to ensure that we meet our obligations to protect our workers when they're in a place that we don't have control over and may not even really understand if it's somewhere overseas? Privacy is another really big sleeper issue for employers to consider. Your confidential information as an employer may not be as secure if you have an employee in another jurisdiction, especially in another country that may not have the same types of privacy laws and privacy protections as we do here. So if an employee is overseas, you need to consider, what are the privacy laws in that country? Could the government access your information? And even before you get to that point, before you're considering the government actually going in to access your information, what about if you have any contracts? A lot of organizations will have contracts with clients whose confidential or private information they maintain as part of providing services to them. They may have contracts that say that you're going to keep their information secure in Canada or in North America. If your employees are going overseas, in some cases, you may not be able to abide by those contractual clauses. And those are really important things that you need to consider and take into account when you're looking at these types of overseas work arrangements. And the last one, and there certainly are more, but the last one that I'll briefly mention here are tax issues. If you're going to have employees working in other provinces or other countries, there may well be tax issues to consider, and there may be additional costs or additional different rules that you need to comply with. So you want to make sure you're speaking to your tax lawyers, your accountants, when you're assessing these types of potential work arrangements. Okay, and so with that, I'm going to shift us to the next section of our presentation here. And that is overtime and hours of work. And so as we get into this issue, just like with the first one, I'd like to use a scenario to really help illustrate this for you all. So I'm going to ask Sheldon to come back on and take us through another client scenario.
Thanks, Joel. So this next scenario that I'll be discussing is a common occurrence that we've seen frequently throughout the pandemic. So as the world has shifted to working remotely, certain provisions of employment legislation became more relevant for employers, such as overtime considerations, the number of hours employees worked, and the employer's record-keeping obligations. To give you an example of a matter we dealt with, this example involves an employee who generally worked in the office before the pandemic rather than working from home. And the employee never worked overtime for at least 2 years leading up to the pandemic. As a matter of fact, the employee typically worked even less than his full-time hours as a salaried employee. The employee also had a manager title, but did not actually have anybody reporting to him. And as many employers know, that is a common occurrence that we've dealt with in many issues. When the pandemic hit, the company shifted to having many of their employees, including this one, work from home for many months. And while this employee was working from home, this employee ended up recording his hours in the company's time tracking system. and ultimately recorded far more than his regular hours and more than the overtime threshold hours. A few months after the lockdown started, the employee was let go because of some unrelated issues, and the employee ultimately made a claim against the company and ended up in litigation. One of the issues the employee raised was that he was claiming a significant amount of overtime pay for the additional hours he had recorded while working from home, and the company doubted that those hours were actually worked because of the fact that the employee never worked his full-time hours in the years leading up to the pandemic, and the employer did have an overtime policy, which required that employees both recorded their hours, but also obtained approval from their manager prior to working any overtime hours. In this case, the employee had not asked for any approval from their manager to work the overtime hours, and again, the employee was recording the time. So the company did have access to that information. Neither the manager nor the employer paid any attention to the hours the employee worked prior to the employee being let go. So Joel, what are the big risks and hotspots for employers when it comes to working hours and overtime entitlements for employees?
Thanks, Sheldon. And as you say, this is another big hot topic, and there are some really important risks that employers need to bear in mind. And why this is such a hot topic is not just that employees are working remotely and you may not have the same level of oversight over them, but there's been study after study throughout the pandemic that has demonstrated that employees in large measure are working more hours than ever before when they're working from home. And with that, of course, comes some risks, even though in many cases it is helping with productivity for a lot of organizations. And so the risks that are associated with these issues really come from some common misconceptions held by a lot of employers. The first of those misconceptions that I want to mention is that many employers don't know that most salaried employees are still entitled to overtime pay. Certainly many of you here today will know that, but I'm sure there are many who aren't aware of that as well. It's a pretty common misconception that people believe that only hourly employees are entitled to overtime pay. If you're salaried, you're just paid your salary and that covers everything. That's not the case. Most employees are going to be entitled to overtime pay, including the vast majority of salaried employees as well. Another thing to keep in mind is overtime pay exemptions. And Sheldon just spoke to this a little bit a moment ago. While it's true that under the ESA and most provinces' employment standards legislation, as well as the Canada Labour Code, managers are exempt from overtime pay and certain other entitlements under employment standards legislation, the employee to be eligible for that exemption has to be a true manager. And in most cases, that involves spending most of their time at work managing people as opposed to performing other types of tasks. And so just giving an employee the title of manager does not make an employee a manager. And that's a point of law that has been adjudicated over and over again. It's a very clear point that a lot of employers have faced a ton of liability as a result of. But even employees who have one or maybe two direct reports, but spend most of their time doing other tasks as opposed to managing their people, in many cases, even they won't be eligible for an overtime exemption and they will be still eligible for overtime pay. So it's a really important misconception that it's important to learn and be aware of as you're considering what you're going to be doing going forward. Now, the next misconception that I want to speak to here is that even if an employer has an overtime policy or a clause in its employees' employment contracts that states that before working overtime, employees have to seek approval to work that overtime, and then an employee goes and works overtime without first seeking approval, they still are entitled to pay for that overtime that they work. Now, a lot of employers, I've had countless calls with employers, both during the pandemic and before, where they say, well, yes, this person says they worked overtime, but they didn't ask, and the policy says they have to ask, so surely they're not entitled to that. That's not how it works. The law is quite clear that if an employee is permitted to work overtime and simply not giving them the authorization is not enough to say you didn't permit them. So if they're permitted to work the overtime, if they're not stopped from working the overtime, then they're entitled to pay for that overtime pay. And so that's really commonly misunderstood, and it's really key to understand that because that's huge here today in the pandemic and following the pandemic as employees are working remotely. While employees are working remotely, it's so easy for them to work overtime without the employer being aware of that, unless the employer takes really clear, strong steps to try to minimize that type of issue. Another misconception is that employers do in fact have obligations to record hours for salaried workers as well. Similar to the overtime, a lot of employers may believe that if someone's salaried, I don't have to track their hours. Again, they just paid for all the hours they work by a salary. Again, that's not how the law works. For the most employees, employers do have obligations to maintain records about the hours that their employees work. Even for salaried employees, the hours do need to be recorded where the hours exceed the employee's regular daily hours. In really all cases, except where the employee is truly exempt from overtime pay. But remember that overtime pay exemption is a dangerous one because a lot of employees who employers think might be exempt may not truly be exempt at law, and therefore there are those record-keeping obligations that apply. What can happen with that issue, and what we've seen happen on countless occasions and helped our clients with, is that employees may be believed to be exempt from overtime pay, and so the managers don't track the hours and they don't pay attention to how many hours the employees work. And then all of a sudden, the employee brings a claim and says, I'm not a manager, I'm entitled to overtime pay. And the employee shows all these hours that they've tracked without even telling the employer in many cases that they've been tracking these hours, and says that they're entitled to overtime pay for all that time. And these claims can be very costly for employers. It can cost tens of thousands of dollars per employee because these claims can go all the way back 2 years for the employee to receive the retroactive overtime pay through a claim to the Ministry of Labor. Now, another key misconception that we have is that a lot of employers believe that employees can work their hours at any time of day, and there's no risk associated with that. In fact, a lot of employers want to allow the flexibility for employees to work in the morning if they want to, in the evening if they want to, take breaks throughout the day. If the operations allow for that, a lot of employers see it as a perk that they can give their employees to help retain and attract great talent. And in some cases, that may well be fine, and operationally it may work. However, employers need to understand that there are certain employment standards obligations that they do have to comply with that can be impacted by these types of arrangements. So a big one is that most employees are entitled to 11 consecutive hours free from work every single day. And so even if the employee agrees, it would still be a violation to allow those employees to work without taking 11 consecutive hours away from work. If you have an employee who's working early in the morning and late at night, and perhaps during the day as well, in a lot of cases, you're going to be violating that Employment Standards Act obligation. Similarly, employees are entitled to certain breaks under the ESA. Specifically, they're entitled to a 30-minute break, or if the employee agrees, 2 15-minute breaks during every 5 consecutive hours of work. And so if the work is being broken up, let's say the employee is working 5 hours in the morning and 5 hours at night, employers do have an obligation to make sure they're taking the breaks that they're entitled to. And it's, again, not good enough for the employee to just agree to not take the breaks. They are required to take them. And as an employer, it's your obligation to ensure that they do so. And lastly, more broadly from an hours of work perspective, employees can't work more than 8 hours per day or more than 48 hours per week unless they agree in writing to work up to another specified number of hours. This is another one that's little known and commonly violated by employers without even realizing that they're doing so. So this is a really key thing for employers to keep in mind. I'm going to take us now to layoffs and termination. I'm going to ask Sheldon to come back up and take us through the third scenario that we've been seeing over and over again during the pandemic.
So this scenario involved a client of ours with an administrative employee who, once the pandemic hit, did not have any work to perform. This was a long-term employee, and it is important to note that this employee did not have an employment contract with a termination clause in place, and the employment contract also did not have a clause giving the employer the right to lay off the employee. As is common with many employers, when the pandemic hit and there was no work for the employee was placed on a temporary layoff by the employer. After a few weeks, the employer started giving the employee more hours in order to help top up the employee's CERB benefits, to not jeopardize the employee's ability to collect CERB benefits going forward. A few months down the road, the employee suddenly sued the employer and alleged that she had been constructively dismissed by having been laid off and by having her work hours significantly reduced since the beginning of the pandemic. This is litigation that we're currently representing our client on, and we have been for some time. And we're now leading up to trial, and the main issue in the litigation is whether the employee was constructively dismissed by having been laid off without a layoff clause in the employment contract. For many employers, this is very common litigation right now and will continue to be litigated in the foreseeable future. We've already seen a handful of decisions, which Joel will touch on. And so Joel, just to ask you, what is the current state of the law regarding layoffs during the pandemic, and how will this impact employers going forward?
Thanks, Sheldon. And as you say, this is yet another very hot topic for employers right now. I will say for us as employment lawyers, it may be a little bit more exciting, a little bit more interesting as a point of law than it is for employers, but it's really important that employers do understand the concepts and the principles at play, because it can result in huge liability for organizations. So really the question right now, that hot topic that I'm referring to, is whether an employee who is laid off without there being a clause in their contract that says they can be laid off as a result of COVID-19, whether that employee was constructively dismissed or not. And this is such a big question because so many employees were laid off at the beginning of the pandemic without realizing that generally you should have a contractual clause saying you can do so as an organization. So the typical rules when it comes to layoffs under the ESA are that employees can be laid off for up to 13 weeks, or if their benefits are continued, for up to 35 weeks without the employee being deemed to have been dismissed under the ESA. But there's also a general common law rule that a lot of employers, certainly at the beginning of the pandemic, were not aware of. And that general rule is that an employee can generally only be laid off if there is a contractual right for the employer to lay them off. Generally, that's done through a layoff clause in the employment contract. So the general common law rule has been, if there is no clause in the employment contract that says that the employer can lay them off, then they're not permitted to be laid off without it being deemed to be a constructive dismissal. Even if the layoff fully complied with all of the statutory obligations under the ESA around layoffs, such as those 13 and 35-week periods that I just spoke about. Now, all these rules have really been thrown for a loop now as a result of the pandemic. One of the big reasons why is that the provincial government, in response to the pandemic, and early on, back in April and May 2020, they released a new type of leave called the Infectious Disease Emergency Leave under the Employment Standards Act. And that type of leave has a variety of different forms, some of which are really key to this layoff and constructive dismissal question. So first of all, with respect to the Infectious Disease Emergency Leave, I'll call it IDEL from now on. First of all, employees can take an unpaid IDEL if they're unable to work for a pretty wide variety of reasons that are related to COVID-19, and they can take that unpaid leave for as long as they need it. So essentially, as long as the circumstances that allow them to take that leave remain in existence. A big example is going to be if the employee has to care for a family member because of a COVID-19 related reason, but there are quite a few other reasons as well that employees can take that unpaid IDEL. Now, in addition to the type of IDEL that I just spoke about, where an employee can actually elect to go on a job protected unpaid leave, there's also a deemed version of this leave. And so what that means is that if an employer, in response to the pandemic, lays off an employee or dramatically reduces their hours or pay by more than half, then that employee, whereas previously they'd be considered to have been laid off under the ESA, is no longer considered to be laid off. They're now considered to be on a deemed IDEL. So essentially what happened there, the provincial government changed the law and they effectively paused the regular layoff rules under the ESA for a temporary period of time. Now, originally, this was really supposed to be pretty temporary, just a few months, up until originally August or September 2020. I'm not remembering the exact date because it's been extended quite a few times since then. Most recently, just in mid-September, it was extended from toward the end of September when it was most recently supposed to expire, right up until January 1st, 2022. So since basically the beginning of the pandemic, right up until January 1st, 2022, any employee who's laid off is not considered to be laid off for the purposes of the ESA, and they're also not considered to be constructively dismissed under the ESA as a result of that. Now, that dispute that I was just talking about in the law, this is the type of IDEL that's really relevant to it. Specifically, there is a dispute about whether this new deemed IDEL displaces that pre-existing common law rule that I mentioned that says that an employee who's laid off without the contractual right to do so is constructively dismissed. So as Sheldon mentioned, we're fighting this issue in court right now on behalf of our clients, and a number of other employment lawyers are fighting this in court as well. We've actually already seen 3 decisions from Ontario's courts about whether that common law rule that a layoff without the contractual right to do so is a constructive dismissal, whether that still exists in relation to these COVID-19 related layoffs. And right now it's a 2-to-1 game. Two of the decisions have said that that general common law rule still applies. So a layoff in response to COVID is still a constructive dismissal if there's no contractual right to do it. But a third decision says otherwise. It says that this legislative change does change the law temporarily. And so those layoffs aren't constructive dismissal when they're related to COVID-19. At this stage, we're waiting for the Court of Appeal to address this and give us some more certainty, and we're expecting a decision in the coming months on that front. But until we get that decision, there's going to be a lot of uncertainty for employers, and those employers who still have employees on layoff or had employees on layoff earlier in the pandemic still may face some pretty significant liability as a result of this. Now, the last point I want to speak about with respect to IDEL is the paid IDEL. So more recently, the government created another type of IDEL, the paid one. And this provides up to 3 days of paid leave to employees for more narrow reasons, but still reasons related to COVID-19. Generally, the most common ones being where the employee misses work to isolate because of COVID-19, to get medical treatment for COVID-19, or to be vaccinated against COVID-19. And in many cases, employers can be reimbursed by the government through WSIB for those paid IDEL days. Now, there's some really key considerations when you're laying your employees off or recalling your employees from layoff in relation to COVID-19 that I want to quickly touch on for you right now. So one big one is, because employees who are laid off are now deemed to be on an IDEL, their benefits have to be continued during that leave unless they've been laid off since very, very early in the pandemic. And that's consistent with the broader ESA leave rules, which say that during any ESA leave, benefits have to be continued. It's also really important that employers track your layoffs, so you know when they started and you know when they may end, so that you can pay attention to when the layoff rules kick back in, the normal layoff rules, when those will expire and when your employees may be deemed to be dismissed under the ESA. It's also really important to document why you're laying people off. And the biggest reason that you want to do that is there's really significant risks if you lay off certain types of employees. Essentially, what I mean by that is if you dismiss an employee for an improper reason, as a reprisal, for example, for taking a voluntary IDEL under the ESA, or if you lay them off for having done so, or if you lay them off because they're not available very much because they're caring for their children or other issues related to COVID-19 or otherwise, you can face really significant legal risks in doing so. And so it's really important to make sure that you're laying people off for objective, valid reasons that don't violate the Human Rights Code, don't violate the Employment Standards Act, and don't violate the Occupational Health and Safety Act. And in many cases, don't violate those by being a retaliation against those employees for asserting their rights under those various pieces of legislation. The last point that I want to quickly mention, for those of you who do still have employees on layoff, employees who are being recalled from a deemed IDEL, they have to be reinstated to their same position, or if that doesn't exist anymore, a comparable position. And again, their benefits have to have been continued throughout the leave. That's again a general rule when it comes to ESA leaves that now apply, because what previously would have been considered a layoff is now, as far as the ESA is concerned, considered a deemed leave. Okay, so that brings us to the end of this section of the presentation. I want to now bring us to the next section of the presentation. As I mentioned, this is going to be the trends to watch, some really, really hot topics that we see becoming more and more relevant and more important for employers going forward. And so I'll pass it over to Nee to take you through.
Thank you, Joel. So there are several trends to watch out for, but let's start with the hot topic of this week. As Joel mentioned, on Monday, the Government of Ontario introduced Bill 27, and that's the Working for Workers Act. And we do expect this bill to become law quite shortly. So if passed, Bill 27 would create new employer obligations as well as a new worker rights for those in Ontario. So some of the bigger amendments I'll be touching upon is the ban on non-compete agreements, as well as a mandatory right to disconnect for larger policy for larger employers. So as you know, non-compete clauses prevent an employee from leaving a company to jump ship and take a new job with a competitor in a set time frame. And so most of these, or rather, these clauses are common in the tech sector. And Ontario is looking to level the playing field and attract talent globally by introducing or amending, rather, the ESA to ban non-compete agreements. Now, this isn't a total ban, so non-competes would still be allowed in certain contexts regarding a sale of business. But if passed, Ontario will be the first Canadian jurisdiction to have a ban enshrined in legislation. So generally, courts presume that non-compete clauses are unenforceable unless they're reasonable in terms of geographic scope, temporal scope, or scope of activities. But that doesn't mean that, or rather we all know that having a non-compete clause in itself can have a deterrent effect regardless of the enforceability. But all is not lost for employers with respect to if this bill is passed, along with the upshot of having spending less time and less costs on litigation. Employers can still use less limiting clauses to protect their proprietary interests. One thing to note, though, as Joel has already touched upon, particularly with the Waxdale decision, if anybody's familiar with it, is that recently courts are becoming less favorable to employers with respect to how they interpret the enforceability of termination clauses. And as Joel mentioned, this can have a significant effect on employees' termination entitlements. Given restrictive covenants, including non-compete clauses, center around an employee's dismissal, we might see issues in terms of the enforceability of the employment agreement as a whole. So it's therefore always a good idea to have your employment agreements reviewed and revised as necessary to avoid issues in the future. And what will likely stem from this non-compete ban is a resignation boom. So during the pandemic, we've seen hundreds of thousands of people leave the workforce, either due to burnout, family status reasons, desire to change careers. And many of these have been in positions that are mid-career, manager positions, high-tech, and healthcare positions. Here, we will likely see another resignation boom with employees who no longer feel the restraint of trade because of these bans on the non-compete. While the non-compete ban may lead to a resignation boom, right to disconnect policies could help with employee retention. Since the pandemic has caused more Canadians to work from home, many workers are finding it hard to switch off at the end of the day. And while Joel discussed employers' liability with respect to overtime hours, the flip side of that is that if an employee responds to work-related communication after hours, that time is usually not considered work time. And this can have a negative effect on work-life balance. So what Bill 27, the Working for Workers Act, proposes to do is require employers with 25 or more employees to have a written right to disconnect policy to encourage employees to disconnect at the end of the workday. If passed, Ontario will also be the first Canadian jurisdiction to mandate a right to disconnect policy. And those who would benefit most from this type of policy would be employees with regular or fixed hours of work. Now, so far, Bill 27 has not prescribed any substantive content with respect to such a policy, but employers should be mindful of how they draft and implement this policy. An inconsistently applied policy could disadvantage workers with family status or disability-related needs. For example, their counterparts might be able to advance due to volunteering to work while others disconnect. In that case, there may be a rise in human rights complaints that we'll see down the road, depending on how companies draft and implement their policies. Since the pandemic, employers who would never consider changing their model are now realizing people can work better from home. And in line with the right to disconnect policy, a reduced work week has been gaining attention as a way to boost moods, productivity, as well as domestic tourism. Increasingly, countries are piloting a 4-day work week with 10 hours per day, and businesses are following suit. Now, Iceland trialed the 4-day work week between 2015 and 2019 with overwhelming success. And basically, the workers were paid the same amount for shorter hours, but they saw either productivity remain the same, or in some cases, productivity actually increased. So a few municipalities in Northern Ontario are starting to test the same model and have found that employees are more efficient and more productive. The Ontario Liberal Party this week has also said that they would pilot a 4-day work week if elected in 2022, with an emphasis on giving employees tools to do more in less time. Now, whether or not this becomes law, employers might want to do this for branding purposes or to see whether productivity actually increases. However, there are still employment standards to consider. So for example, as Joel mentioned, overtime legislation is not the same across Canada. So for employers who have operations across Canada, you do want to make sure that you're complying with the legislation, relevant legislation of the province or territory. And Joel has already mentioned in British Columbia, although Ontario doesn't have a daily overtime employment standard, British Columbia, if the employee is working for more than 8 hours a day, the employer is responsible to pay them for overtime for that day. I believe Joel also touched upon breaks. So for every 5 consecutive hours worked, the employee is entitled to a 30-minute break. And so for an 8-hour workday, that is 1 break, but for a 10-hour workday, the employee would be required to take an additional break. So another trend to watch out for is travel time. Now that employees are working from home on a regular basis, this may have an effect on what is considered travel time. So commuting time and travel time under the ESA are treated differently. So when employees are commuting to and from work, employers aren't responsible for paying for that time. However, if employees are traveling during the workday, employers are responsible for paying for that travel time. When employees were regularly going to the office, their commute to the office the employer did not have to pay for that. But now that employees are working regularly from home and their usual workplace is home, if they are required to occasionally go to the office, there may be a risk that employers would have to pay for this time if it's considered travel time. Now, speaking of pay and compensation, under the ESA, home workers are a defined class of employees who have an increased higher minimum wage than other classes of employees. And recently, as you may know, Ontario increased their minimum wage to $14.35, but increased the home workers' wage to $15.80 an hour. So what is a home worker? Basically, a home worker is an employee who does paid work from their home for an employer. And this is not to be confused with a domestic worker who does paid work in other people's homes. So what's important about this home worker wage? Well, in the age of COVID-19, everyone who works from home on a non-temporary basis is a home worker, and they would be entitled to the increased minimum wage. Now, this isn't something that's on many employers' radars. However, if you are an employer thinking about moving to a work from home model and you have employees who earn a minimum wage, you should be mindful of the home worker's wage and how this might affect your business's budget. Also, as Joel mentioned, employees are able to make claims extending back 2 years from the last incident. So this could mean that employers are liable to pay thousands of dollars to each employee who is considered misclassified. So right now, there's no precedent on the issues of travel time or the home workers' wage with respect to the pandemic, but we will likely see more claims arise in the new world of work as we see employees are working more regularly at home. Of course, in representing employers, the best thing to do is to avoid claims altogether. So with that in mind, I will kick it back to Joel to discuss best practices for employers.
Thanks so much, Nee. And certainly huge hot topics and trends that employers need to be looking out for going forward. And so let me speak about how to really make sure that you're protecting yourself against those, as well as some of the other issues that we've been talking about here today. And so, first of all, when it comes to best practices, the first thing that you should be doing as an employer is auditing your employment standards compliance. It may sound obvious, it may sound simple, but it's something that a lot of employers don't do, and it would be something that can really protect you. And so what I mean by this is really pop the hood, take a look, assess what you're doing and where you may have some exposures in relation to all of these different issues that we're talking about. So for example, to touch on a few of the things we've talked about here today, assess whether you have employees working in other provinces or other countries. And if you do, consider the risks that are associated with that we were talking about earlier. Consider whether you have employees who are working more hours than the ESA permits, and with respect to whom you're not complying with the ESA's hours of work obligations, as well as the obligations around breaks, the ESA's record keeping obligations, and more. Assess also whether you have employees who are working additional hours at home, like so many employers now do. And if you do, assess whether those employees are actually being paid overtime pay in accordance with the ESA. And if they're not, if you have huge overtime pay exposures that you're gathering here. Also, assess whether you have employees who are or who were laid off in accordance with a layoff clause, not in accordance with a layoff clause under a contract, to determine whether you have some exposures there. And finally, with respect to what Nee was just touching on, assess whether you may be paying your employees who are working remotely and who are minimum wage or near minimum wage employees. Assess whether you're actually paying them the home worker minimum wage, or whether you might be violating the minimum wage obligations there. Now, why I say this is so important, we regularly conduct employment law audits for our clients, including employment standards law and more broadly employment law audits. And whenever we do these audits, we find invariably quite a few exposures where employers in many cases don't even realize that they're exposed to liability. And so if you do that yourself or obtain some assistance to do so, it really can help you protect yourself, protect your downside. If you just leave it and hope there's not a claim, usually ultimately the claims are going to come. And if one employee files a claim, for example, if one employee files an overtime pay claim and gets a big award, chances are the other employees will find out and will file one as well. So better thing to do is figure out how you can ensure compliance from the outset, like Nee said, to avoid the liability going forward. So the next best practice we want to talk about here, draft and revise your policies to ensure compliance. There are a few here that I've mentioned, and there are so many more that you should be considering in relation to the content we've discussed here today. But the few I'll speak about here, first of all, remote work. If you're going to allow your employees to work remotely, whether that's remotely within Ontario or even more importantly or more concerningly outside Ontario or outside Canada, have a policy where you clearly spell out what the expectations and the rules are for those arrangements. Also, make sure that you implement or revise an overtime policy. I mentioned before, I'll admit, an overtime policy alone is not going to be enough to protect you. Even if you have an overtime policy that says employees have to get permission before working overtime, if they do work the overtime, they're still entitled to that pay. Absolutely. However, it's a key tool that you need as an employer, along with other tools, to ensure that you can avoid overtime liability going forward. For example, if you have an overtime policy and you have an employee who's not complying with it, if you're complying with your record keeping obligations as well, and you know when those employees are working, you can ensure that you performance manage or discipline those employees for violating your policy and not getting approval before working the overtime. And that can help reset the way that employees work and ensure that you're avoiding that overtime liability that you might otherwise face. Another one, consider your hours of work policies. And in relation to that, look at the incoming obligation for most employers to draft a right to disconnect policy. Ensure that your policies clearly outline your expectations around hours of work. Ensure that you're directing your employees to work in a way that complies with the various hours of work and breaks and hours free from work obligations under the ESA. And again, now ensure that you're going to implement one of these right to disconnect policies if you're one of those employers that this applies to, those employers with 25 or more employees, to ensure that you're complying with these new obligations that are going to come into effect soon. So the last few best practices that I want to speak about here, first of all, this one seems obvious, but again, it's one that is missed so often. Train your managers. Train your managers on ESA obligations, train them on your policies, ensure they understand where the liabilities lie, and ensure that they understand how to hold their employees in accordance with the policies to make sure that you're avoiding your liability. Like I mentioned a moment ago, the overtime policy is a big one, but alone it doesn't do enough. The people who are going to be able to track those hours and performance manage or discipline where employees aren't complying with the overtime policy are those who are the frontline managers dealing with the employees day after day. You need to make sure that you train them to make sure that they understand the policy, understand the implications of the policy, and are ensuring that they are enforcing it consistently. You also want to train your managers, of course, on all the other policies that we've been talking about here and the other obligations, because if the managers don't understand what the implications are, chances are they may not feel it's that important and they may not really follow the direction that you're giving them through a memo or an email. Make sure there's clear training for them. The next point that I want to talk about here is revising and implementing your employment contracts and considering implementing remote work agreements as well. So there's a couple of big developments that we've talked about here today that really go to employment contract enforceability. One, the new ban on most non-competition clauses that Nee was talking about in Ontario. If you have non-competition clauses in your contracts, for example, even if you understood that they may not be enforceable anyway because of the common law rules around them, you may have had them in there as a deterrent. It's time to get those out of your contracts. The deterrent effect is not enough to outweigh the negative impacts that these clauses may have going forward once they're banned in Ontario. Why that's the case? They may, for example, be, these clauses may be banned going forward. And if you have these clauses, it's possible that the courts may say, well, you have this clause in there that is prohibited, and this relates to the employee's termination entitlements. That may result in your termination clause being something you can't rely on either. And there's other types of implications of these as well. So you want to get those out of your contracts going forward. In addition to that, as I said, if you have employees outside of Ontario and other provinces working, make sure that you have contracts that reflect that. Make sure you don't have a contract that just says, for example, in a termination clause, they'll receive their termination entitlements under Ontario's ESA. Because if they're an employee working in Manitoba or Alberta or BC or wherever, and that's what their termination clause says, you probably can't rely on it because that's not, they don't have entitlements under Ontario's ESA. The important one is the entitlements under the provincial legislation that applies to them. In addition to revising them again, you want to make sure you implement these correctly as well. Simply having the contract is not enough. You have to implement them in the right way. So for your existing employees, that means giving them the contract, giving them time to review and get legal advice if they choose to. And most importantly, that means giving them consideration, giving them something of value in exchange for signing off on the new contract. And it's really important to remember the compensation they already have, the job they already have, a bonus that they're already entitled to receive anyway. That's not consideration. It's got to be something new when it comes to existing employees. And as I mentioned, consider remote work agreements. These can really help you ensure that the employees follow your remote work policies and ensure that you can minimize the liability that we talked about around remote work. So with that, that takes us toward the end of our presentation. I want to remind you before we shift to the Q&A segment of our last and third segment in the Hotspots New World of Work webinar series coming up on November 25th about evolving issues in workplace investigation. So we hope that you'll all be able to join Laura Williams and Alex Pressey for that presentation in about a month's time. Related to that, I want to put on your radar, we recently issued our latest newsletter. We put these newsletters out a few times a year, and our latest one is a special edition all about workplace investigations, which is such a hot topic right now because of the new ways that the employees may be harassing each other, but there may be discrimination, all the different things that we're seeing because of the changes in the way that we're doing work. We're seeing more investigation issues as well. So that's a great one you can download from our website. And finally, I'm going to take us to the Q&A. Being mindful of the time, I know we're just about at the end of our scheduled hour for this time. So for anybody who does have to go at the end of the hour in 2 minutes, thank you so much for joining us here today. I'll remind you again that we are going to be sharing the playback and the slides. The slides will be sent to you along with a link to the playback on our COVID-19 Resource Center. So again, thank you all for coming. And for those who can stay on, we're going to stick around for another 10, 15 minutes and answer as many of your questions as we can before we wrap up here. And so I'm going to keep myself on the hot seat. I'm going to be answering the questions for you, but I'm going to ask Nee to come on and help me by asking the questions and giving me a chance to breathe between answering them.
So we've received a ton of great questions. So thank you for that. Keep them coming. Don't be shy. But let's start it off. So Joel, in terms of the working overseas or in a different province, is there a set period of time where the employee would be considered to be an employee of another province, an employee of another country, for the purposes of, which legislation would apply?
I really wish the answer to that was yes, but unfortunately it's not. It's that classic lawyer answer. It depends. It depends on where they're working. It depends on, what they're doing there. It depends on how often they're coming back to Ontario. And so this is something that, if you do have employees working in other places, you really should get specific advice so you can understand what the liabilities are. And again, it's employment law advice, but it's also tax advice and other really important advice that you need to obtain when you're considering these types of arrangements.
And similar to the other provinces thing, I'm seeing a few questions about the holidays. So, for employers who have operations across Canada and want employees to comply with, for example, only Ontario, they want it to keep it consistent across the board. Is that something they can force or encourage their employees in other provinces to do?
That's a great question, and it's one that we get all the time. It's why it's one that I mentioned during the presentation as well. Unfortunately, the answer again is it depends, but I can give you a little more on this one. So it does depend on the province where the employee works, because again, employees are subject to the provincial legislation in their province when it comes to employment standards generally. And so because of that, you need to look to the legislation in the province where each employee works. But as a very general rule, in most legislation across the country, most employment standards legislation across the country does provide that employees and employers can agree to a substitute holiday instead of the regular holidays that they have. So same, just like you have in Ontario, where an employer and employee can agree that the employee works on the holiday and gets another paid day off, most other provinces have the same option. Generally, you can't force the employee to work on the holiday other than in pretty limited exceptions. But generally, you can agree with the employee to have them work and take another day off with pay, or give them some extra holiday pay with premium pay if you don't give them an extra day off. And so in most cases, you can agree with your employees. And in my experience, many of our clients do have the ability, or do have their employees who are willing to agree to these types of things in recognition of how important that can be for operations.
So people are curious about the IDEL. One question in particular, how does the extension of and we keep seeing it extended, the IDL affect the employer's responsibility to continue benefits during a layoff?
So very good question. Employees do, if an employee is on a essentially a layoff, effectively a layoff, but they're deemed to be on the IDEL, like I said, those who are laid off in response to COVID are, the obligation is to continue their benefits unless they were laid off again very early in the pandemic before the rule was created, which if I remember correctly was approximately late May that this rule was created, and it was implemented retroactively. But for those who had already laid their people off and stopped their benefits, the benefits didn't have to be continued. But anyone else who's laid employees off as a result of the pandemic, they are going to have to continue the benefits for the duration of the deemed IDEL, which again, as of now, it's scheduled to end on January 1st, 2022, but it's very possible it's extended again. It's been extended 3 or 4 times already, and it could again. Now, if an employer does decide that they need to let that employee go, there is a bit of a quirk to the deemed IDEL. So although ESA leaves are generally job protected, the job protected nature for the deemed IDEL leaves has a bit of a quirk. And essentially how that works is, if the employer lets an employee go for reasons unrelated to COVID, essentially, or even if it is related to COVID, if the employer wants to let the employee go, they're no longer deemed to be on the IDEL. So the job protected nature essentially ends when the employee is let go. And if you let them go, the obligation to continue their benefits will end at the end of the period during which you're required to continue them under the ESA or the common law. And that's when your termination clauses or the common law termination entitlements will kick in to dictate how long the benefits have to be continued at that point.
Thank you, Joel. I have a question here. So in industries where overtime is common, is it enough to have a general clause in the employment agreement stating overtime is part of the job, or should it be more specific in terms of maximum overtime hours?
So I expect this question relates to the fact that generally, as I said, in Ontario, employers need to have a certain number of hours that the employee will work up to in their contracts. And so even where overtime is common, you still do need to indicate in that agreement with the employee that they're going to work, additional hours beyond 48 and however many they may be expected to work up to in a given weekend, however many they may be expected to work up to in a given day under the Employment Standards Act. This is one of those clauses that is less commonly enforced, I will say, by the Ministry of Labor. However, it's always important to try to maintain compliance wherever you can, even on these that may not be audited by the Ministry of Labor as often. Because if you do face an audit, for example, and they find out that that's something you're doing wrong, even if it doesn't result in huge liability, it may then cause them to pop the hood and look a little deeper and see what other violations there might be, and those can be more costly for employers. Now, when it comes to the overtime pay piece of the question, just to ensure that I'm answering it in the most fulsome way possible, if an employee is required to work overtime and they're not exempt from overtime pay under the Employment Standards Act, such as if they are a legitimate manager under the ESA, then they're going to have to be compensated for the overtime pay. You can't just say, your salary compensates you for all of your hours, including your overtime hours worked. You actually need to compensate them specifically hour by hour for the hours they work over the 44-hour overtime threshold for those of you in Ontario.
So Joel, you were talking about, why it's important to have good policies in place, but what if only one of your employees is working from home, everybody else is still working, at the office or at the center or whatnot? Should these employers still implement a work from home policy?
It's always going to depend on the situation, of course. If there's just, one individual who is permitted to work from home, perhaps, a one-on-one agreement between the employer and that individual can make sense. It really depends on the specific circumstances. Generally, the policies are a good way to go. And if there's a chance that more employees may end up working remotely, then that can help give the opportunity to the employer to ensure that you already have the policy in place when others start working from home as well. But if that's not going to happen, if it's a type of workplace where there's just no way that others are going to work from home other than the one, that may be something that can be agreed between the employer and the employee directly.
So I have two questions about the right to disconnect policy. I'll ask them back to back because the one will be very quick for you to answer. 25 or less, or sorry, less than 25, does that mean no mandated right to disconnect policy? And then stemming from that, when they say 25 or more employees, does that also include part-time employees, supply staff, and other non-full-time permanent employees?
So 25 employees, to my knowledge on the legislation, again, it was just tabled this week. So it's possible that there is something that is there or that's going to be added that I've missed. But to my knowledge and understanding, 25 employees means 25 employees, no matter how many that may be. Sorry, Nia, I'm not sure if I missed another part of the question there.
And then just like less than 25, would that require a mandated right to disconnect?
So as it stands, as the legislation has been tabled, no, the legislation is for those, call them medium-sized and larger employers that have at least 25 employees only. The others would not be required. Now, from an employer branding, employer reputation, attractiveness perspective, of course, it may be prudent to put these policies in place, because as these become more and more common now that they're going to be mandated for most employers, it's going to become it's going to be something that many employees may expect and want to see from an employer. And so, although it may not be mandated, it may be something to do voluntarily.
Now, people are curious about remote work, and I have a question. How do we manage temporary remote work scenarios? Is it best to have a specific agreement in place with set timelines?
So this is one of those specific questions that I would say that whoever asked this question, I would encourage you to get specific advice about it, because it really depends on some other circumstances. But if you want to have a kind of blanket across the board rule as far as how long employees can work elsewhere, employees can work elsewhere for up to a month, for example. Perhaps that's something that you can have a blanket policy, and that can just be a provision of your policy. Now, even if you do that, it may be beneficial, like I mentioned during the presentation, to also have individual remote work agreements with each employee to make sure that it's absolutely clear to them what the expectations are under the policy and that they specifically agree in writing to all the different components of the policy through a specific standalone agreement. Now, on the other hand, if it's really going to depend on each employee and whether and how long and in what circumstances you may allow employees to work remotely elsewhere, that may be something that you want to keep the policy more general and then have the specifics in each agreement. For example, if you have certain types of roles that can't be as far away or can't be away for as long, then you may want to have different rules for them, and then specific agreements would be the best way to go to do that.
So speaking of agreements, somebody asked if they're revamping their agreements and rolling them out, do they have to provide a signing bonus for employees?
Thanks, Nee. So great question. That goes back to the consideration point that I was speaking about during the presentation. So for existing employees, in order to give them a new contract and be able to rely on that new contract, again, you need more than just their signature on the contract. One of the things that you can use, and a very common one that you can use to give that consideration, that thing of value to ensure the contract is enforceable, would be a signing bonus. So that's a common one that many organizations will do, a signing bonus, perhaps even a gift card, whatever the case may be. That's not the only way, though. You don't need to give a signing bonus. It could be something else as long as it has value to the employee. So sometimes employers will give a couple of extra days off, extra paid days off work, either going forward, more vacation going forward, or even just a couple of extra days during that same year. A bit of time off around the holidays, for example, is often something that employees really want and can really serve as a beneficial consideration for the employer. And in many cases, that won't have a huge operational impact, given that a lot of businesses do tend to slow down around the holidays.
So somebody had a question with respect to the home workers' wage. They've asked if an employee is already working from home, but they actually earn more than the minimum wage, and I'm assuming above the minimum home workers' wage. Does the employer have the obligation to increase their wage if they're working from home?
So the answer to that question would be no. If the employee is already earning more than the home worker minimum wage, you're compliant already. The minimum wage requirement under the ESA, and there's a variety of different ones. There's the general one, there's the home worker one, there's the liquor server one, etc. As long as the employee is receiving at least the minimum wage for the type of employee that they are, then that's going to be compliance. Now, if you have employees who are working from home and they're earning, for example, 50 cents more than the regular minimum wage, but still less than the home worker minimum wage, then yes, very likely to ensure compliance with the ESA, they would have to get an increase up to at least the home worker minimum wage if they're going to continue to be home workers going forward.
I want to circle back to remote work outside of the province. I found this question pretty interesting. So if an employer is considering allowing an employee to work a few months, several months outside of the province, is it a good idea to have a new employment agreement in place for that?
Very interesting question. And I would say in many cases, yes. In many cases, you want to have a new employment agreement or some sort of kind of addendum to the existing agreement that addresses what's going to happen while they're away. So, for example, if you decide to have an employee who's typically based in Ontario, you want to allow them to go and work in British Columbia for a year before coming back, then having a specific agreement that addresses the fact that that's where they're going to be, that it addresses how long they're permitted to be there, and addresses the relevant legislation while they're there. Again, in this case, the British Columbia Employment Standards Act would be the important one in the example I'm giving. Then that would be a really good idea. That can help protect. So I'll give you an example why. If, for example, 6 months after the employee goes, the employer decides they need to let that employee go for whatever reason, without cause, whether it's because the employee is not performing as well, whether it's because business demands have changed, whatever the case may be. If the employer decides to let that individual go and they haven't put in place a new contract that makes it clear that termination entitlements will be in accordance with the BC ESA, very likely that employee is going to be entitled to common law reasonable notice rather than the much lesser statutory entitlements under Ontario or BC's ESAs.
So Joel, I think this will be the final question given our time, but they're both questions about timelines. So maybe instead of because we can't see into the future necessarily, it would be a good idea for you to let people know where they can find the answers in terms of our website and things like that. So somebody has asked, do you believe, whether the IDEL will be extended again after January 1st, 2022? And then another question about the new legislation, so the Bill 27, Working for Workers Act, when do you think that will be enacted?
Yeah, thanks, Steve. Those are both very good questions. I'll try to read the crystal ball for everybody, at least for that first one. So, what I would say right now, the numbers are looking better. And so I will say conditionally, if the pandemic numbers, the COVID cases in Ontario continue to look better and better, and they don't start skyrocketing again, as we've seen them, do again a number of times, then I would say likely the IDEL regulation would not be extended again, and it will end January 1st, 2022. However, if, like we saw last year, the case numbers start going up and up and up in the coming weeks as it gets colder and people are going inside, I would say there's a pretty good chance they'll extend it again, as they have been doing in response to increasing case numbers these past 18 months or so. Now, with respect to the Working for Workers Act, I would anticipate that will come into effect quite shortly. Again, as you spoke to during the presentation, that legislation is tabled by the Minister of Labour of the Conservative government. They do have the power in Ontario, and they very likely will push that through quickly as a big important point that they want to raise. So look for that to come quickly. To Nee's point, we will be addressing both of these points on our website. So on our In the Know blog on the main part of our website, as well as in the COVID-19 resource center that we have that you can easily get to through our williamshrlaw.com website. So I encourage you to keep an eye there. Follow our social media as well. We post updates on these types of things on LinkedIn and Twitter as well. So please follow those, and we'll make sure that we're getting these developments up as quickly as possible. And we tend to do it very quickly when there's big developments like these two that we're just asked about. So as Nee said, that's the last one that we have time for here today. Again, really appreciate all of you joining us here today for the webinar. We hope that you've gained a ton of really useful knowledge to take back to your organizations. If you do have more questions, please take a look at our resource center. Please feel free to reach out to us, and we're certainly happy to assist. So thank you again to all of you for joining us. Thank you to Nee and Sheldon for your great presentations here today, and we hope you all have an excellent rest of your day. Thank you.